right, good afternoon, everybody. Thank you for joining us today. We enjoyed presenting these topics every month. This month's topic, and Kathryn and I were together last month, if you had a chance to join on that one. This month's topic is one that comes up quite frequently in our practice in various types of businesses. In law, we see it in connection with if a deal is about to go forward or people are doing due diligence. If you're operating in, especially in worlds we see a lot with healthcare and technology, confidential information and privacy are significant concerns when folks are doing business together. And also at the, if things blow up and you go into litigation, there's additional confidentiality concerns. All of that brings us to the topic of today on dealing with confidentiality and non-disclosure agreements. Again, my name is Boughman, and I'm joined by Kathryn Jones.
Yeah.
Kathryn, nice to be with you again today.
You.
And we've got a lot of material. Again, this is stuff that we see all the time in our practice. But the agenda looks long with several different areas to touch upon when we're dealing with confidentiality issues. Any specific words of wisdom as we jump in, Kathryn?
Not really. I just wanted to just kind of mention that there's different contexts that we see these in. I see them most frequently in transactions where people are buying or selling their businesses. I also see them in employment and independent contractor agreements, wherever there's a legal relationship between two parties, it comes up. And I think, Eric, you have more experience in the litigation universe, but in the context of negotiated settlement agreements, that's another frequently seen use of these confidentiality and non-disclosure type agreements.
So we see confidentiality issues come up when people are in litigation. They oftentimes, when cases are settled, parties want that to be confidential. I actually am becoming more of a fan. I've mentioned this in prior presentations. I'm becoming more of a fan of arbitration as an alternative form of dispute resolution instead of litigation, because when you have litigation, your problems, all the matters in litigation are public, and anybody can go find that information. And if you're a business, you don't want to be. Yeah, and I know we just got done doing that. When you have to disclose litigation, but due diligence, people are looking you up. And if I have a client who's not sure about doing business with somebody, one of the things we might do is do a litigation search. Just see how litigious are the folks that we're thinking about doing business with. And if the name pops up 10 times, whether it's as a plaintiff or as a defendant, when you just see a whole bunch of lawsuits, it gives you pause. So that's, we look at confidentiality in that context, resolving lawsuits, and how do we stay out of those things. And you can look at that on the front side of a deal by, for instance, agreeing to an arbitration provision. But the other thing with confidentiality is litigation over confidential information. And that leads me to, I think, the big, as I'm thinking about today's presentation, the overarching point that I think I want people to take away today is think of your confidential information as an asset, just like your bank account. Your bank account information is an asset. Confidential information for many companies today, your confidential information can be among the most valuable sources, most valuable assets that you have. And so you need to treat it and protect it like an asset. And sometimes you need to guard it and defend it like an asset.
Right. And so here, some introductory bullet points here. Well, we're going to talk about, the concept of it being a business asset and protecting it as such. The different types of confidential information that a business has, different formats of confidentiality and non-disclosure agreements, and things to consider as you're drafting the agreement, both from the perspective of the disclosing party as well as the receiving party. We talked a little bit about the business context in which confidentiality agreements are used, and then we'll discuss best practices, kind of a day-to-day kind of thumbnail guide for protecting confidential information.
All right, so the types of confidential information, there's a list here. The big ones that we see a lot, business strategy, what does that mean? It depends on the type of business, your marketing plan, your customers, your referral sources, budgets. Think of it, if you are bidding on projects, on government projects or big development projects, or you're going to be a vendor for a specific client, The information that you use to create your bid and what your bid is going to be. You don't want everybody to know about that.
Mm-hmm.
If all of your competitors know how you're going to bid and how you derive that bid and how you generate your profits, they can use that to undercut your
Mm-hmm.
interests. So obviously financial information, employee lists, if you sign a confidential, if you're, for instance, looking at somebody who might be coming in to get involved with your business or buy it, you don't want them coming in and poaching your employees and poaching your customers. So you need to consider that information. What other things? Recipes.
Yeah.
Confidential recipes. Yeah.
And again, this kind of, it depends on the industry, obviously. So software companies, they have an emphasis on code and things that they're developing. A manufacturing company may have emphasis in their processes, things that make their widgets better than others. So the list, while there are commonalities across industries, when you're drafting these types of agreements, one of the things you want to keep in mind is what your client's particular industry is, and if there's anything specific within that they want to specifically mention when defining the universe of confidential information for purposes of the contract.
And here, I think the next slide just has some more further lists of confidential information. Take a look at this top bullet: trade secrets and unpublished patent applications. This is a common debate, I suppose, or a common issue that comes up with if you come up with an idea and that idea is unique and you think it's potentially patentable. What you have to decide is, do you want to patent it and rely on patent protection, which makes your information public? Or do you want to try and maintain the secret? If we think of some of the most well-known confidential products, so to speak, the formula for Coca-Cola, the formula for WD-40, these are, there's nowhere where you can go look up. You can look up maybe the patent for an automobile, but you can't look up the patent for Coca-Cola because they've chosen to keep that secret. So that's kind of a fundamental decision that you have to make early on. We're not patent attorneys, so we don't deal in that world, but certainly if you're going to come up with a unique product or unique information that you think is saleable or marketable, that's one of your early considerations. And if you are going to consider keeping it confidential, start from the beginning. Maintain that confidentiality early on, because that's going to be one of the factors, as we'll see, when courts determine whether or not you have confidential information, whether it can be treated as a trade secret, is whether you've treated it and protected it as confidential from the beginning. One other point on the last one, there was also some reference, and I made reference to litigation. You can keep it there, but in arbitration and litigation, parties will often in the course of litigation or an arbitration decide that they want to keep information confidential. Sometimes courts can be resistant to that, or if you have a party, if you have multi-party litigation, I've been involved in cases where there's 10 different parties and somebody doesn't want it to be confidential because they realize that the public record is damaging for other parties. And different courts take different views on that, but some of the courts will look at it and say, well, this is a court proceeding, it's public information, make it more difficult to keep information confidential. If it is confidential, you could file things under seal. That usually has to do not with the pleadings and the allegations, but more with the evidence that's produced. But another advantage in arbitration, I feel like I'm doing a sales pitch for arbitration. Another advantage in arbitration is when I've done arbitrations, we just agree to a blanket confidentiality agreement. Everything's confidential. Nothing's getting publicly filed, and the entire file's confidential. I've never had an arbitrator or anybody push back on that. So another thing to consider, that if you find yourself in that situation, you could try to maximize the confidentiality of even a dispute.
Just some additional items that are protected and may qualify for additional protection, I guess, under trade secret statutes, under state or federal law. Again, a lot of it depends on the industry you're in. Marketing plans, client lists, those kind of span everything. But when you're getting into software or manufacturing or other type of specific industries, that would be subject to whatever is applicable in that industry. So why are we doing all this? Again, you want to, when you're drafting these documents, and again, it's difficult to kind of anticipate every little thing that's going or should be confidential. But what you're trying to do is to avoid confusion and have some clarity or baseline as to what the parties are agreeing is confidential information. Second bullet point, flexibility in defining what's confidential. Again, this comes into play when if you have a specific industry or something, a term of art, you want to make sure everyone knows that this particular thing is confidential in that industry. Level setting expectations on how the parties are supposed to treat confidential information exchanged between them. Obviously, something in writing is easier to enforce than something oral. So just from a record keeping standpoint, having something written is going to help a lot. And then this last bullet here, upstream agreements. You may have a service provider whose agreement requires confidentiality agreements with subcontractors. So if there's a link or if there's multiple providers or a hierarchy, you're going to want to make sure everybody within that stream has confidentiality obligations in place.
We see that in a lot of technology, and we see it in healthcare with BA business associate agreements, where if you're a vendor, you may be required to have the BA in place with all of your subcontractors. And one of the more well-known recent disclosures was it Equifax that had the data breach, and apparently the breach came from one of their vendors who wasn't protecting confidential information.
And then in a deal setting, if you're selling a business, it comes up where you make a representation to the buyer that you've protected all your confidential information, that you haven't had any breaches, or if you have had breaches, they've been disclosed. If you use subcontractors or vendors like tech vendors, for example, you keep your stuff on Google. Big companies like that, you can have a reasonable reliance that they've done everything that they can to keep your data private and secured. But ultimately, as the seller, if you're relying on third parties, you want to make sure that their terms of service adequately protect and have safeguards in place to protect your data.
And here's a point when we've seen this several times. I mentioned this earlier with having your employees and certain data. If somebody's coming into a due diligence and they're looking at a company for maybe a purchase or a merger and some type of contemplated transaction, you also will often see, and we will want to include some non-solicitation language. So if a company comes in, for instance, and they're interviewing some of your people, you don't want them trying to make job offers to the same people. So there might be some type of hands-off agreement for a period of months or years, even if a deal doesn't go forward. And that will be oftentimes found in an initial non-disclosure confidentiality agreement that appears early in the deal contemplation process.
Second bullet point here, covering issues that are indirectly related to confidentiality, such as non-solicitation. Again, the language would say something to the effect of, a customer list is confidential and it cannot be used, disclosed, disseminated other than in the furtherance of the discloser's business or further benefit. Here, if you have somebody who has your confidential information, if the language is written the right way, they can't use it to solicit business from your customers and kind of end run your business. So that's it's an indirect benefit, is that you can restrict solicitation, kind of in a backdoor way by restricting disclosures. Okay. The structure, again, it could be a freestanding agreement. It could be a clause within a larger agreement that governs a legal relationship. And again, no matter where it is or the form, the purpose is to keep things quiet. Down here, conducting diligence in the course of negotiating a definitive agreement. This is where I see it most often. There may be an NDA or something circulated early on, particularly if you have an investment banker that is soliciting potential buyers for a business. There may be something very early on before anything is even disclosed specific to a particular target, that there's going to be an NDA. That's typically a freestanding because they just don't have enough to build the LOI yet. You'll see again later when the LOI comes to fruition down here. This is the bottom bullet point here. The LOI will have, typically it's non-binding. It'll have the general business parameters and understanding of the parties as far as purchase price and the form or the structure of the transaction. Most of those provisions are non-binding because the parties are still in diligence. They're refining kind of what the deal is going to look like. typically what is binding are confidentiality provisions within the letter of intent. So you'll see maybe an NDA, a freestanding NDA signed early on, an LOI that maybe restates and reaffirms the parties' agreement to abide by the terms of the NDA. It may have additional confidentiality provisions, but those are binding. So if, let's say, the deal's off or the terms change, those are still in place and enforceable by the parties.
And if we get a look at one of those, if we get an LOI, for instance, that has reference to a separate confidentiality agreement or an earlier NDA or an agreement, some type of language that says that we're going to incorporate the terms of an earlier NDA or confidentiality agreement, we want to go back and look at that.
Right.
We want to see what the language is to make sure that that covers this. That will generally work. But especially if you're, especially in the context of a transaction like Kathryn's talking about, if you're the seller, you're essentially opening up your books. You're getting, for business and financial purposes, you're getting naked for the seller to let an investigation go forward. You want to make sure that you have a lot of protection if the deal does not ultimately close.
Particularly if your potential buyer is actually within your industry. Let's say you have a smaller company and a larger company wants to come in and establish maybe a footprint in Florida, and you've got a great footprint in Florida, but they're also engaged in the same line of business in other parts of the country. Well, you open up your books and, that may give them the roadmap and how to establish their footprint without actually buying the business. So again, as a seller, it's really a big deal to make sure your confidentiality provisions are tight from the very beginning.
And we usually see these with the slide here that talk about different types. Usually we see 2A, and there's often, I've seen one-way NDAs or confidentiality agreements on occasion, but normally both parties just agree we're going to keep confidential information confidential. The biggest issue is really how is the confidential information defined and identified.
Yeah.
And sometimes we're required to be stamped or some other indication. But that's usually probably the biggest first issue, is figuring out how we're going to treat the confidential information at the beginning by identifying it, and how are we going to treat it at the end. Right.
Again, not much on the unilateral side. Typically, we see the mutual or the reciprocal format. Here, your strategic or alliance or joint venture with an outside party. Again, both parties are bringing something to the table, so both would have, presumably confidential information to protect and also to exchange to bring as part of the joint venture. Again, going back to the settlement agreement context, there's interest on both sides to keep things quiet. I don't think anybody wants their business out there more than it has to be. So that's a situation where you'd have a mutual.
I did have a recent one-sided NDA, and it was one-sided. It was just one direction. A unilateral NDA was a client with new medical technology that they had someone else evaluating, and they were actually going to send a prototype product, or did send a prototype product to a potential suitor for purposes of maybe marketing or developing that product more broadly. Or for another might be where you have a prototype product and you're looking at manufacturing. There you may see unilateral, because you're just giving up the product to somebody else, letting them evaluate it and then give it back to you. But even in, say, the manufacturing context, you still would probably want some type of mutuality, because if you're giving information to allow somebody to evaluate for purpose of whether it can be manufactured, you're going to learn about their manufacturing processes. Right. So again, I come back to probably 80% of the time, 90% of the time mutual, but there are some contexts where I see the unilateral. And the third type is not very common, the reciprocal type agreement, unless you see it very often.
No, you see kind of variations. I think when you're hiring someone to do something for you, and this goes to the third paragraph here, in essence, you're giving them permission to use your confidential information, but solely for your benefit and solely to the extent necessary to perform the services that they're being hired for. I think that's kind of, implicit. I think that's common sense, but you want it written out, because if it's a license, then you can terminate it at any time. They're not getting any ownership or any proprietary rights. Their only, right is to use it for the benefit of the the company that's hiring them to perform the service.
Now, you may write in specific expansions of those rights in that agreement where they can, they have the right to, you're sharing information with each other, and then you know that that agreement contemplates them sharing it with third parties.
Right.
And then they'd be responsible for protecting that
third parties.
confidentiality with the third parties.
Right. So limitations, I think kind of the biggest and probably most effective safeguard is to figure out who you're disclosing to, why, and how much you need to disclose to achieve your purposes. This can go be even before you start drafting anything legally, just kind of figure out who you're dealing with. Whether they can be trusted, and again, maybe a litigation search or something in the public record to show if just to do your diligence as to who you're doing business with. Again, once it's out, it's out. It can't be undisclosed, and you want to.
This is really becomes more of a practical consideration too. That you can have a written document, but time and again we come back to who are you doing business with, who are you talking to, who you're engaging with. So even if you have a written confidentiality agreement, you still want to be diligent about what information you disclose and to whom you disclose it. And this is the issue here is what once the bell is rung, you can't unring it. And you'll often see language, and certainly most of the confidentiality agreements we deal with will treat as confidential that information which has been treated as confidential by the parties. But once that information becomes public knowledge or is released by somebody who's not one of the parties, it's no longer treated as confidential. In other words, if Kathryn and I have a confidentiality agreement, but something I disclose to Kathryn in confidence suddenly becomes public knowledge and is on the front page of the New York Post, it's no longer, Kathryn doesn't have to treat it as confidential.
Unless I'm the reason why it went public, right?
Unless the reason, and then confidential sources, right? That's what they use for the information. And getting injunctive relief, while that sounds great, and a lot of confidentiality agreements will have language that says, well, you're entitled to go seek injunctive relief if this information is disclosed or a threat of being disclosed. Candidly, you have that right anyway. That language is oftentimes redundant. Maybe for a threatened breach is a little bit more appropriate. But injunctive relief isn't all it's cracked up to be. You have to. It's a lot of work. I just was involved in an injunction hearing yesterday. There's a lot of work that goes into it. It can be expensive. Judges can contour the terms of injunctive relief as they believe is most appropriate. It may not be what you anticipate or what's in your agreement. And you generally oftentimes have to post some type of cash bond to get an injunction. So if it's really valuable stuff and the other side claims that they have a right to disclose it and they're going to have a financial injury because of the injunction being entered, the judge can order a bond be posted to protect that party in case it later turns out that the decision to enter the injunction early on in a lawsuit, which is what would be required. You'd be required to have a lawsuit for this. The judge can order the party to post a pretty significant cash bond. I had
a question on the bond issue. I've seen before where the parties they'll say in agreement that they're waiving or they're waiving that. Is that even
great
something
question.
that can be enforced?
Depending on the jurisdiction, in Florida, I prefer a nominal bond to waiving the bond. There's cases on both sides, but most of what I've looked at, there could be something that's changed recently, but my last recollection is that you can't waive bond completely. We'll see nominal bond. I don't know if $1 is going to do it. Will $1,000 do it? Better to try to identify maybe to put language in the document, in the confidentiality agreement that says, look, if there's a breach of this confidentiality section, I could suffer significantly, but you don't suffer harm either way. You have no interest in disclosing the information, so there's no damage that you're going to suffer by being ordered by a court not to disclose it. And when you have that language in there, what that means is they later can't say, well, we're going to have a lot of damage if we can't disclose this. Instead, you've agreed that your damages are very nominal for being ordered not to disclose, not to do something, and you can use that as justification for your nominal bond later, and that's how you get there. But generally, the court rules and jurisdictions that I'm familiar with, where I've seen this come up, you generally have to post a cash bond in order to get an injunction.
think also the amount of the bond, or whether you want to say in the contract you're waiving it, is really from the perspective of who's it trying to protect. If you're the disclosing party, yeah, you're going to want to address that, and I just, again, it's very specific, I think mostly jurisdiction, and also if you're the lawyer, who you're trying to protect. Confidentiality policies. I think a lot of businesses, if they don't have one, they should, as far as a formal policy on how to treat customer information, for example, or patient information if you run a healthcare practice. The policy should be implemented, written down, and communicated to employees or anybody who's handling this kind of information. Again, tailor it to your industry, whether you're in healthcare, payment processing, financial services, legal services, any kind of industry where you're dealing with sensitive information, there should be a policy in place.
And I'll just add that with healthcare, while this isn't a HIPAA seminar, certainly, if you are in the healthcare context that involves information protected by HIPAA, there are specific requirements and there's specific rules regarding disclosures and inadvertent disclosures and documenting those and when they have to be reported to HHS and so forth. So just be cognizant of that. Most people in that industry will know that, but if you have any questions, that requires a little bit of a deeper dive. But you do have additional reporting requirements in healthcare specifically.
And again, if you're looking to kind of position your business for an eventual sale, your confidentiality policy is something that the buyer's going to request. If you have one, if you don't have one, they're going to ask why and what you're doing, kind of, on a day-to-day basis to protect your confidential information.
Yeah, and when you have the policy, make sure that people know about it and that you follow it.
Mm-hmm.
One of the biggest, this is related a little bit, but a related but separate issue is privacy policies. We often get asked to look at privacy policies or to maybe draft privacy policies for website. Everybody's got a privacy policy. Some people just pluck them off the internet and put them on their website. The biggest question I ask is it's very difficult to analyze a privacy policy to determine whether or not it is legally compliant without actually knowing what you do from a privacy perspective and what you're doing business-wise to protect the information that you're calling that you're addressing in your privacy policy. And where a lot of companies get hit and where they run into problems, it's not because they have not followed some particular law with respect to privacy policies, but what they're doing is different than what the policy actually says. And then you run into an issue and it falls under either the FTC under the federal, the FTC hits you under the FTC Act, or under state Unfair and Deceptive Trade Practices Act. So you use federal or state unfair and deceptive trade practice, potentially Computer Fraud and Abuse Act, but really that unfair practices or deceptive practices.
And again, in the deal context, they're going to ask if you have one, and also if you have one, you haven't followed it, or if you're in breach, disclose that, tell us what it is, and we'll figure out if that somehow affects either the decision to move forward with the deal or the economics of the deal. If the buyer thinks that there's some kind of risk that they may have to absorb later, they may try to negotiate purchase price or whatever to try to recoup that from somewhere.
Can I stay on this one for a second too, as well as I see what information that you're going to disclose to third parties. So Kathryn's talking about in a deal context, you may need to go back and get permission from somebody else to disclose information. Right. So if you've got confidential information and you're looking at a potential deal, you may need to go back and get the other party, your counterparty, to agree that you can disclose that, or it may be written into the document. You may get subpoenaed for information. I've had that come up several times, where you're subpoenaed and the information you have is confidential. So you need to get either a court order or some type of permission from the parties. I've had state agencies recently. I've had a couple clients contact me where state agencies are just asking these regulated businesses for information, and if they're a state agency, I tell them to come back with an order or a subpoena. You're not just going to give it to some investigator or some inspector because they show up and say they want to take a look at it. And then I mentioned privacy policy, so I'll touch on it again. Customers, if you have a privacy policy and you are potentially doing something with customer information and data, if you're either selling it or if you're looking, we just got done helping somebody sell a business where this became an issue or was a question. If they're looking at the customer information what does your privacy policy say about what customer information can be shared with third parties? So you want to look at your privacy policy and see, am I allowed to disclose who my customers are and what information about my customers can I disclose? The ways that that might be disclosed are, on an individual customer basis or on an aggregated basis. And so in many contexts, you'll see where you can't give up individual information. I can't say, well, Joe Smith spent $1,000 with us last year, but I can say that we had 1,000 clients who spent a total of $1 million with us last year. So the aggregated information can be provided, but not individuals. Again, make sure that what you have, any other documents or agreements, including privacy policies or other confidentiality agreements, are consistent with whatever information you're being asked about.
Right. So when you're receiving it, what should you consider? Again, Eric mentioned checking your we're talking about the disclosure side, but when you take it in, also check your non-disclosure obligations under your agreements, your customer agreements, privacy policies or whatnot. Excuse me. Figure out who in your organization has a need to know. And if you have an industry where security clearances or whatever are needed, make sure that your employees are properly cleared before receiving that information internally. And then, so these are just general things to consider when you're on your intake. Pardon me. In drafting, what do you want to consider when you're putting these documents together? We typically, a common structure that we see is, a parent holding company, a number of subsidiaries. For instance, if you've got a medical practice, you have a holder, and then each subsidiary, if you have a different location throughout the state, you could drop each into a subsidiary. Those are all part of a common enterprise, or they're a family of companies. When you're drafting, you want to make sure that if it's only one particular entity that's disclosing something, you want to build in protections for the entire enterprise. So you may want to include affiliates, subsidiaries, parents within the enterprise as protected under the confidential provisions, even if they're not the direct party to the confidentiality agreement. Also consider your business purpose and the whereas clauses. You want to mention, we're evaluating a marketing arrangement or evaluating a transaction, and state the party's intentions as to why the agreement is appropriate. And
just to kind of hit on the affiliate issue, common ownership and control. So if you're part of the same business arrangement, there may be different entities that technically are involved. So anybody that's under common ownership, management, or control. Also, you may want, if you are operating under a confidentiality agreement, you may want the ability, probably do want the ability to share the information with your professional advisors, attorneys, accountants, other folks. And then this, drafting the business purpose is much more important in the context, I think, of a confidentiality agreement than it would be, like, for instance, when you see operating agreements or bylaws or articles of incorporation that just say we can do any business purpose. I've seen that in confidentiality agreements. What's the business purpose? To engage in potential business together. That can be dangerous because it makes more broad the other party's ability to use that information. It can be more harmful if you're giving up confidential information. Whereas in the example here, if it's to evaluate a potential marketing arrangement between the parties, if your counterparty takes that information and goes off and goes marketing on their own, that's clearly outside the business purpose. So that type of language can be important in this context.
Defining confidential information. This is something that as a drafter you struggle with, because you don't want to make it over broad, but you don't want to make it super narrow where you could lose protection over things that your client thinks is an important bit of information to protect. So I look at this and it really, it's so specific as to the circumstances, but there are certain things that you want to include all the time. But again, you want to be kind of discreet and thoughtful in what you're defining as confidential information.
Where I see people overuse the definition of confidential information is in lawsuits. Parties will enter into an agreement. in a lawsuit, they'll enter into a confidentiality agreement. Sometimes it'll be adopted by a court or an arbitrator. And again, in the arbitration context, often we'll just say everything's going to be confidential. That's different. But if you're in court, depending on who the other parties are and who you represent, for instance, if you're in a lawsuit with a publicly traded company and you're suing that publicly traded company for fraudulent activity by some of its directors, they don't want any of that information to be disclosed. And you may want as much as possible of that information to be disclosed. So just be cognizant of that if you find yourself in that situation where you've got a party who wants to mark everything as confidential. And you'll usually in that context, you'll require the documents to be marked. You can do it without a law. You can do it in any confidentiality agreement. You can have, what we're going to treat as confidential is this stuff that should be confidential, or certain types, categories of documents, or stuff marked confidential. But in a lawsuit, it typically will have to be marked confidential. And I've been on both sides, especially on the side where I thought the other party was overusing the confidentiality label, and challenge it. And we'll go back and sometimes bring that issue before court. It's just something to be aware of, that sometimes people can overuse it or interpret it too broadly.
The second bullet point here, must the disclosed material be marked confidential? Right. When you're thinking about that issue, I think it depends on really who you're representing. If you're the lawyer, right? If you are representing the disclosing party, I mean, do you really want your client to have this burden of having to mark every single thing confidential, or possibly lose protection? Yeah,
what happens if they forget? What happens if they forget? Right. Disclosure, that's all potential problem.
Yeah, and if you're the receiving party, you're going to want some certainty as to what exactly the disclosing party, is expecting to be treated as confidential. So if you've got a big watermark on something, I think it kind of alleviates a lot of the ambiguity. So again, depending on who you're trying to protect, it could go both ways. Exclusions from what is confidential information, typical carve-outs, or anything that becomes public, if it's already in the recipient's possession, it's received from a third party that didn't have a confidentiality obligation, or is developed by the recipient without using the confidential information. Again, this last one I think is a little bit difficult in practice, because how do you know? Like, once you disclose and they build something, how do you really know what was theirs and what was the recipient or the disclosing party? So
very tough to it's very tough to show that it was known. Maybe easier to disprove. Well, the way you can show that it was known, the other way, it's tough to disprove, but easier to prove if you've got some type of time-stamped or dated communication regarding the information. So somebody shares confidential information, say it's pricing data about about a particular product or customer, and if I have a client and somebody's saying, well, you breached confidentiality, but I've got an email that's dated 2 weeks before the confidentiality agreement discussing that specific information, well, that's going to show that there was no violation. But without that email, it's very tough, as Kathryn says, to prove or disprove that.
Let's see here. I wanted to hit on down here where it's disclosing party. If a disclosing party is typically, when you write these, if a party is being presented with a court order or some kind of legally required disclosure, if you're the disclosing party and you want to protect your information, you're going to want the opportunity to challenge that court order, or try to obtain a protective order to limit the scope of the disclosure. So in these confidentiality agreements, typically we'll see language that says, okay, if you get a subpoena or something, you'll notify the disclosing party within X number of days after receiving the subpoena or the order, and to allow them the opportunity to seek a protective order, or kind of review internally what's okay and what's not okay to disclose. It's just a safeguard that's in place, for the disclosing party.
Yeah, so that it comes up in the context of exceptions, and these are typically drafted into the confidentiality agreement. I'll tell you, as a practical matter, if I have a client who's under a confidentiality agreement and we get a subpoena or a court order for certain information, or if my client gets subpoenaed to show up and bring stuff with him that is subject to a confidentiality agreement, regardless of whether there's language is in there, if it's my client, we're going to notify the other party. Hey, we've gotten a subpoena, want to let you know. We want to do everything we can to protect ourselves by laying the groundwork for the fact that we are just going through the compliance and we're not violating the confidentiality agreement. But then, another issue that comes up in connection with disclosing to the other party is, what duty do you have to cooperate? And sometimes that's it can be a point of contention in negotiating these, is, what requirement do I have? If you tell me don't disclose and I am under an order to disclose, and then you say we're going to file a motion for a protective order, do I need to wait and get the results of that motion for protective order? Do I need to join in the action or be joined in the action? Do I have to engage? Do I have to have any expense? What if I have to hire an attorney to go appear in that action? Who pays for that? If you want the most protection and you're the one giving up confidential information, you want to offer to pay for that and just say, look, you will reasonably cooperate at our expense to protect our confidential information, and make it as easy as possible for the other side to comply.
Another consideration is how long. How long do you have to keep this information confidential? Eric, is there some kind of judicial guidance on that, or is that?
There's not none that I'm aware of. Let me say it differently. There could be that I'm not aware of, but I have had this question come up. In my view, you have confidential information, it gets disclosed. Oftentimes, you don't want that information released ever. But there are some times when you'll see, okay, the confidential. I guess the question is, if the confidential information doesn't have a specific release period, what's the term of survival of the enforceability of the confidentiality agreement? If it's part of a larger agreement, you agree to terminate the agreement and it survives, does it survive indefinitely or survive for a limited amount of time? Candidly, I don't see that question come up much. I haven't had a situation where somebody says, well, this should only survive for a year or two. What people are worried about is an inadvertent later disclosure. That's really what is the concern. Is that, gosh, what if we get this information, we sign a confidentiality agreement, we look at a deal, you'll see, I think we have something in a slide coming up here where we talk about, what's the treatment of the information if the confidentiality agreement or the agreement that confidentiality provision is in is terminated. What are the duties with respect to the party who receives information? Do you destroy it? Do you return it? Once that information is returned or gone, what if there's some type of disclosure a couple of years later? Are you on the hook for that? So that's really the biggest concern. And that's where you have to worry about, well, for how long am I required to keep information confidential? I think if you couple that with a requirement to return or destroy all the material, anything that shows up later, it either suggests you didn't return it or destroy it, or that it was independently developed. Although now that's even changing because of archiving requirements. So now we're seeing more parties are required, or businesses that are archiving information, and we're starting to see carve-outs in confidentiality agreements that says, well, we'll return or destroy everything except that stuff that's been archived, that's in our computer systems that we can't access. I haven't done a deep dive into that, but I've seen that now more often, where parties are saying it's not practical, or we can't go get that information out of our archives, but it's also not readily available. So we'll keep it confidential.
I think there'd be some kind of reasonableness if you were ever having to argue to a judge that something should be kept quiet. Like if the information went stale, let's say you've got something that over time just becomes obsolete or it loses its value, is it really, is there any damage?
I think that's more the issue that happens. Is you've got a trade secret, you've got something of value today, but if you're, for instance, if you're the seller of a business and you're signing non-disclosure confidentiality agreements, you have potential buyers signing those agreements. If 2 years later you have sold the business, you're not too concerned about somebody now disclosing information, although the buyer of your business may be a little concerned. But you're right, the information is more likely to go stale.
This is a slide you're talking about what happens when a relationship ends. I see this a lot in employment or independent contractor relationships where the employee leaves. Well, what's their duty or what's their obligation as far as disposing of confidential information? A lot of times you'll see in employment agreements, they have a duty to return everything or wipe clean their personal devices to the extent they have confidential information on there, certify it in writing that it's been done. If you're a recipient and you just, it may not be practical to physically return stuff, you may want the option to just delete it and certify that it's been deleted. Again, some carve outs to that obligation for archival or evidentiary purposes, or if you're just required to keep it by some law or regulation for a certain number of years. You don't want to have to destroy it or return it.
And Kathryn's using a fancy legal term there, and
What's that?
certifying the information
Right.
as destroyed, which is actually typically my preferred mechanism at the end. And the question, and by that, what we're referring to is really just giving a written document.
Right.
That doesn't have to take any specific form. It's just a document that says, I hereby certify, and if you're doing it on behalf of a company, I, Joe Smith, hereby certify on behalf of Smith Corporation, I've destroyed all this information, and you sign the document, you deliver it to the other side. Sometimes that will be an automatic requirement, or sometimes it'll be required on request. I kind of like on request, and the reason for that generally is that, look, if we ask for the document, you should have no problem giving us that. If you have destroyed everything, I don't know why anybody would give any pushback. But with a lot of these, if a deal doesn't go forward, the parties aren't thinking about it a whole lot, and give them an affirmative obligation that can then subject them to some type of breach claim or some claim of liability because they didn't comply. I just don't like I don't like breaches that occur because somebody just wasn't careful enough. So that's typically language that I like in there. Certify upon request, or upon request to certify the information will be destroyed. And we talked about this earlier with I think we mentioned that, depending on where you are is going to dictate what some of your remedies are. And I wanted to make one other point on the confidential information too. You can stay on the slide, but just on the enforcement, we're talking about it now, and in enforcing. Well, this is still in negotiating, but when you're talking about governing law and jurisdiction, we're talking about how to enforce a confidentiality agreement. If you think that an agreement has been violated and your information is out there in the marketplace or is going to be disclosed, you also need to act fast. So we were talking a couple slides ago about whether or not confidential information loses its confidential character by virtue of the fact that it goes stale. The confidentiality is stale because now it's well known. Well, if you know that a party has released your confidential information and you decide, I don't know if I want to do anything about it, you wait months, that time period that you wait could create an issue for you when it comes time to enforce it, because a court could say, you waited several months, it doesn't seem like it's that important to you. So you need to act fast. It's one of those times when we don't tend to rush clients into litigation, but if you want to get a court order, an injunction, or some type of protection for that information, you need to act right away. So keep that in mind if you do think there's been a potential breach, or if you think somebody's going to breach. If you know, for instance, that a subpoena has been served, try and get out there and get a protective order before you respond. I've had several clients where they get information subpoenaed from them, accounting firms. It's very common. We represent some accounting firms, and they get subpoenaed for information, and there's certain protections that we ask for. We may give up the information, but we want a court order with protections. These provisions here for governing law, jurisdiction, venue, these are often confused by folks who don't, by non-lawyers who don't do this all the time. Governing law is just which state's law applies. So if the governing law is Florida, or if the governing law is Delaware or Nevada or somewhere else, we look to that state to tell us what the law is, but the jurisdiction for enforceability can still be in a different state. We can have an agreement where the enforcement jurisdiction is Florida, but Delaware is going to be the governing law. It's a little strange, but you can do it. Venue is where disputes will be resolved. And if you're a company we're located in Florida, if you're a company in Central Florida and you're doing, you're entering into this type of agreement with a company in Kentucky, you prefer any disputes probably be resolved here in Florida and not have to go to Kentucky to resolve a dispute. Although you could probably drink a lot of bourbon. And then type of dispute resolution, that's whether it's going to be a court action, whether you have arbitration, which could be private. Other advantages, with arbitration and mediation, which I also am a big fan of, is that a lot of that you can do a lot more electronically. You don't have to make personal appearances, although the courts are getting up to speed with COVID on that. anyway, these are legal decisions, and I agree with the, this at the bottom there where it says consult with legal advisors. It's a good idea to figure out what the best mechanisms are.
Great. So just a summary of best practices. We talked a lot about this, but just to recap, limit disclosure to who needs to know, contractual protections, in your NDAs and your confidentiality agreements, security measures. They haven't really talked about that so much, but, just have reasonable technology in place to keep, breaches from happening. Confidentiality issues when employees join and leave. So on your intake, make sure they're properly trained. If you have a written policy, provide a copy and then have an acknowledgement that the employee, signs that says that they received the copy and the training. Also, when they leave, again, have them, destroy confidential information that's on their personal devices, return any physical, tangible copies of CI that they may have in their possession. Having an internal policy and holding your employees and contractors to is very important. Again, it doesn't do you much good to have a policy if you don't enforce it. Train employees and prepare for inadvertent disclosure. So if something comes up, have a plan in place. If that plan is calling your lawyer, great. Have your internal, if you have in-house counsel, make sure that they're notified immediately as to a potential breach, and then you can plan accordingly.
If you have a rogue employee or someone who's disgruntled, someone who leaves on short notice, particularly an employee that you think may have taken or would have reason to take or use your confidential information, what I have done with clients previously, and sometimes will recommend depending on the circumstances, is that you run a scan, get your technology folks to run a scan of your computer systems, particularly that employee's computer systems, and wherever your confidential data is housed, if they had access to it, run that scan over the past month before the employee left and find out the activity. We have found situations where those scans reveal that the employee was downloading large quantities of information onto detached storage drives, downloading it into Dropbox, coming in on the weekends and accessing. That's a big red flag. If you've got employees who don't typically work weekends, and all of a sudden on the weekends they're accessing confidential information, you should probably be monitoring this anyway. With the computer systems today, you can monitor who's going in and out of different files and databases. You should keep the confidential information. Again, a key here is it can't just be in with the regular files. The stuff that's really confidential, you need to segregate that and put it somewhere else. There's certain businesses where that, law firms, for instance, all of our stuff is privileged and confidential. We still use encryption technology and other, but we have to protect the information at a higher level. So financial firms, healthcare, but for other businesses, consider who you're giving access to for this material. And then watch it once in a while. Ask your tech folks to give you a report. Who's been in and out of the confidential files, who's opening up things they have no need to open up. And that's, you have this language that you see in confidentiality agreements a lot that says that it's accessible or can be shared with people who have a need to know. Nobody ever defines that term, need to know, but it's kind of one of those things when you see it. If you're seeing people who don't have a need to know information accessing it, that should be a red flag.
Absolutely. Need to know.
Limited. Okay, maybe this must have been. I slept with this under my pillow last night.
Osmosed. This slide here just gives a few references to statutes that may provide some remedies with respect to folks who may intentionally use or disclose confidential information. So again, when it comes down to enforcing, you may have contractual rights, but you may also have additional rights under applicable law that you may want to explore.
So we see the Defend Trade Secrets Act is a federal trade secrets law that's still relatively new. It's been around for a few years. Most states have some form of the Uniform State Trade Secrets Act, including Florida at Chapter 688. That's the one that we typically look to. Computer Fraud and Abuse Act. That is one that still that can be subject to very broad interpretation. So if you misuse, there's misuse common websites like social media sites and try and get confidential info, like crack into somebody's Facebook account, that could be considered a violation of the Computer Fraud and Abuse Act. It's pretty broad the way it's been interpreted by courts. But I have to admit, I have a client, he's international, he's involved in a unique technology. He's from Europe. His company is based out of Europe, and he does business here in the US with some defense contractors. And he mentioned something about ITAR recently, the International Traffic in Arms Regulation. And I have to admit, I had no idea what, I've not had any dealings with that regulation before this client brought it up. So if there are any ITAR specialists out there, or if you know somebody who's a specialist with ITAR and with the export administration regulations, that comes up sometimes in dealing with international, please reach out to me. I'd like to make contact with somebody that I might rely on as a source of knowledge and information there, potentially referral.
All right, we doing on time? We good on time?
I think we're good. We got a couple minutes left. We got 1 or 2 slides. What do we have? We're at the
This is our
conclusion.
conclusion. So again, takeaways, it's a valuable business asset and treat it as such. And then, in doubt, call your legal advisors, whether they're in-house or outside, as to what your duties and obligations are, whether you're a disclosing party or a receiving party. And if you feel like there's been some kind of violation, consult with your advisors as to what your potential remedies and recourse may be.
Yeah, act fast.
Yes.
If you think there's been an issue. And that's it. So thank you very much for joining us today. If there's any questions, we're happy to field them. We have on our last slide there, we got our contact information. You can reach out. If there's topics that you'd like to see, we've talked about, we're due for some ethics, and we also have technology for our Florida requirements. So some of the attorneys, we're talking about doing maybe an ethics with social media is one that we might potentially do in the next month or two. We get some credit if we teach that. If we give you valuable information, you get to use that, and hopefully it's interesting as well. So have a great day, everybody. Kathryn, anything final words?
That's it. Thank you all for joining us.
All right.
Take care.
See you next month.
Bye-bye.